Good afternoon, everyone. We may have some folks still joining us, but let's go ahead and get started. Good morning or afternoon, depending on where you're joining us from today. My name is Debbie Brenneman. I'm a partner in the Thompson Hine Labor and Employment Practice. Probably spoke with a lot of you last week. I'd like to also welcome you to today's webinar, and I'm fortunate enough to have with me today Kim Wilcoxon, one of my partners from our Employee Benefits Group. And as we get to the question and answer session today, we'll also be joined by another of our partners, Megan Glowacki, from the Labor and Employment Practice. So from now until about 12:45, we are going to share our presentation regarding the very newly enacted Families First Coronavirus Response Act and how it will impact leave issues and group health plans. During the webinar, please feel free to use the question box, typically located in the control panel to the right of your screen, to submit questions. I see many of you already are doing that. We do have over 600 folks who registered for the webinar today, so it may well be that we cannot get to all of the questions during our time together. If we don't, we will respond via email after the webinar. This is also being recorded, and we will send a link to all attendees early next week. So let's get started first with some of the provisions of this very newly enacted statute, the Families First Coronavirus Response Act, which was first passed by the House on bipartisan vote on March 14th, signed into law, passed by the Senate and signed into law on March 18th. It had been reported that the Senate passed the House Act without change. That's not quite accurate, because before the House actually submitted the bill to the Senate, it made an amendment, which it called a technical amendment, but which you will see as we walk through this, actually made some pretty substantive changes, really scaled back the provisions of the Act to lessen the impact on many small employers. So we'll see how that plays out. The leave provisions become effective on April 2nd, 2020, whereas group health plan provisions do take effect immediately. The first thing I want to talk about is how to calculate the number of employees, because these acts only apply to employers with fewer than 500 employees. And we've had a lot of questions this week on exactly how do you calculate that threshold if maybe you have multiple operations. We hope and expect that the DOL will possibly issue guidance on this threshold. We're expecting some guidance within the next 15 days before this takes effect. But at this point, what employers should do, we think, is rely on an integrated employer analysis. And that's the analysis that's commonly used to determine coverage under both the FMLA and various anti-discrimination laws. Now, the unfortunate thing is with the integrated employer test, as with many things in employment law, there is no black and white answer, just a lot of gray and varying shades of it. But these are the factors that are commonly used to determine whether there's an integrated employer such that you might fall over that 500 employee threshold. No one of these elements is determinative. It is an analysis of all of them. The first three of these factors tend to have more weight. So you look at things like whether there is common management over day-to-day operations, same authority over day-to-day operations. Is there an interrelationship between operations? Are there common offices, for instance? Is the same record keeping taking place? Does the personnel policy apply to those different locations? Are there commonalities among directors, officers, those sorts of things? Centralized control over labor relations. So is there a common control over decision-making authority with regard to employees, hiring, firing, promotion, those kinds of decisions? And the final factor is the degree of common ownership or financial control. So are there the same owners of the multiple facilities? Those are the types of things that you will need to take a look at if you are hovering around that 500 threshold and you have multiple operations. Again, stay tuned. We are hopeful that we may get some guidance on this. We see a lot of questions arising. This legislation was passed very quickly by folks who may not have, may not be sensitive to some of these issues as they play out with employers. So we do hope that we will see some more definitive guidance on this and a lot of other issues as we go through. So there are two components that I will be talking about today, the two paid leave provisions that are in the new legislation, again, that takes effect on April 2nd. The first one is the Emergency Sick Leave Act. And once again, it applies to private sector employers with fewer than 500 workers who can't work or telework, provides them with paid sick time. So if you have employees who may fall within the categories I'm going to be talking about, but they can telework, then you will not be required to pay emergency sick leave if they can do that teleworking. So that's another analysis that you'll have to make. Now, these factors also changed between the original act and what we saw passed by the Senate and signed by President Trump. The first of these factors is one of those changes. So your employees, if you're under 500 employees, will be eligible for emergency sick leave if the employee is subject to a COVID-19 federal, state, or local quarantine or isolation order. So I just saw, for instance, in the last few moments before we started, that Governor Cuomo has now issued an order that for non-essential businesses in New York, 100% of their workforce has to go home. There has been a lot of talk about whether Ohio will come under a shelter-in-place type of order, such as we've seen in California and Pennsylvania. So that cuts a wide swath. If you become subject to a government-ordered isolation order or quarantine, then your employees are going to be eligible for sick leave effective April 2nd. The next category is if the employee has been advised by a healthcare provider to self-quarantine due to COVID-19 concerns. So we did see some language before about an employee who is self-quarantining. This revises it to say that they've been advised by a healthcare provider to self-quarantine due to these concerns. The next category is if the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis, then that employee can obtain emergency sick leave. It also extends to employees who are caring for an individual subject to a COVID-19 quarantine or isolation order, or an employee caring for an employee who's been advised by a healthcare provider to self-quarantine due to those same concerns. So basically, if the employee is caring for somebody who falls within those other couple of factors, that's going to qualify for emergency sick leave as well. Emergency sick leave is also eligible if the employee is caring for a child, and this is a child 18 or under whose school or place of care, daycare facility, etc., is closed, or if the child care provider of the child, and that is a child care provider who receives compensation. So if grandpa watches the child but is not paid for it, that technically doesn't come within the act. But a child care provider who receives compensation, if that provider becomes unavailable due to COVID-19 precautions, the employee is eligible for the paid sick leave. The final prong is the employee is eligible if he or she is experiencing any other substantially similar condition specified by Health and Human Services in consultation with the Treasury and Labor Departments. So that's kind of your catch-all, and I read that to say if someone is self-quarantining because they think they have COVID-19 symptoms, or you send them home because they believe they are exhibiting COVID-19 symptoms, but maybe they are not seeking a medical diagnosis that puts them in another prong, they are probably covered by this component of the emergency sick leave. The only difference, as we'll talk about in a few minutes, is the rate of compensation that they're eligible for, depending upon which of these buckets that they fall into. With regard to compensation under the emergency sick leave component, full-time employees are to receive 80 hours of sick leave, and we're going to talk in a few minutes about exactly how that's calculated. Part-time workers are to receive leave equivalent to their average hours worked in a 2-week period. Now, this affects every employee. So you may have an employee who started yesterday or on March 31st, and on April 2nd, they're going to be eligible for this requirement, and they may not have worked a 2-week period. What the regs say is that you should look to the hours that you anticipated them working at the time of hire. That should be your calculation there. And again, the sick leave in either instance is available for immediate use. So their tenure at your place of business is irrelevant. There is a 10-year requirement when we get to the Emergency Family Medical Act, but not with regard to the emergency sick leave law. Now, with regard to pay, and we'll have some more variations of this, but workers taking leave for themselves will have to be paid at least their normal wage or applicable federal, state, local minimum wage, whichever is greater, subject to some limits I'm going to talk about. And workers who are taking time off to care for family members are paid at 2/3 of the foregoing rate, subject to the caps that we'll talk about. So if they're taking leave for themselves, full rate of pay. If they're taking leave for those prongs relating to caring for family members or self-quarantining under the last prong, they're paid at 2/3. Sick leave, however, so it's 80 hours at their rate of pay, but it is capped. So sick leave is capped at $511 per day for full-time employees, $5,110 in the aggregate for that. With regard to part-time employees or those taking care of others, rather, that is capped at $200 at the 2/3 rate. Wages required to be paid under the emergency sick leave provisions are not subject to the 6.2% Social Security payroll tax. So those are not subject to that, and this paid sick time is not going to carry over year after year. It expires on December 31st. If it's not used, it will not carry over. With regard to your obligations, there are a lot of questions about what about other sick leave policies? How is this going to play out? Employers with existing paid leave policies will be required to provide workers with the sick leave under this emergency program. You cannot require a worker to use any other available paid leave before using the sick time. An employee may choose to use other leave or other leave first, and perhaps that's a situation where they would be entitled to PTO that wouldn't cap out, but you cannot require them to do that. You will see if you read the text of the statute that while the prior version before the quote-unquote technical amendments had a specific prohibition about this, there's not a prohibition, but the way the regulation or way the legislation is written, it says that it is the employees, it is their election, their discretion whether to use any other leave before using this sick time under this act. It is important to note that employers of employees who are healthcare providers or emergency responders may elect to exclude those employees from the emergency sick leave provision. So technically, healthcare providers, as more broadly defined in DOL regulations and FMLA, are doctors, and other healthcare providers can include those, obviously those who work for those. We do expect to see the regulations anticipate some further clarification on this and regulations by the Department of Labor. We do expect that we will see those as well. We've had some questions this week about what if you have an unlimited paid time off policy, and we are seeing this as a trend with employers that some folks have gone to a flexible or unlimited paid time off policy. As a practical matter, there's really not going to be an election then between what's provided in this and what you're providing anyway under unlimited. We have had some internal debate, and again, this is something that we're hoping that we can see some further clarification on, is you want to be able to take that tax benefit that's available from giving folks this paid leave. So we would think, under a reasonable interpretation of this, that the initial leave could be self-designated as falling within the paid sick leave so that you could recoup those tax benefits, but that is not spelled out by the legislation itself. There are a couple of other prohibitions on employers that are set forth in this particular leave component. Employers cannot require workers to find replacements to cover their hours during time off. So you can't say, okay, but hey, before you go, can you help me find somebody to cover your meeting tomorrow, or cover this task, or cover your desk while you're gone? You cannot place that burden on the employees. That will be the employer's obligation and burden to find that. And also there is an anti-retaliation provision in the emergency sick leave component. There is not per se an anti-retaliation provision in the expansion of the Family Medical Leave Act, and I suspect that's because it is an amendment to the Family Medical Leave Act, which in itself contains an anti-retaliation, anti-discrimination provision. So you will still be prohibited from discriminating against folks on the basis of taking that expanded leave, but it is not specifically spelled out in the amendment with regard to that. You are required to post notice containing information regarding the emergency sick leave provisions, and the Department of Labor is supposed to be providing us with a model notice within a week of March 18th. Now, as a practical matter, a lot of us are already having our employees do a lot of work from home, a lot of telework. So although the legislation itself does not impose obligations regarding posting a notice, we may see further regulations with regard to providing email notice or via other electronic means. And I think as a practical matter, what I'm seeing is employers affirmatively sending out that kind of notification to their employees to make them aware of the opportunities that will be effective coming April 2nd. Again, timing becomes effective April 2nd, 2020, and it will expire on December 31st, 2020, absent some further act of Congress. A lot of questions have come up as well about can the provisions be applied retroactively. Many people have already sent folks home. Many people have already been quarantined for various reasons. So can that leave that employers may be paying now, can that be applied? Can employers go ahead and take the benefit if they send folks home now and pay them? We don't think so. There's certainly no provision in the Act that makes it retroactive. So I think if you have sent folks home or if you're paying them now, that's great, and that's probably a good business decision, but that is not going to fulfill your obligations, we don't believe, under the Sick Leave Act itself. And also, very importantly, we don't think that would entitle you to the tax benefits that are available through the Act if those are not done after the April 2nd date of enactment. So I know that there was some language about the Act will take effect no later than 15 days, but it's broadly acknowledged and that it takes effect April 2nd, and I think that language was just due to a little bit of uncertainty about when exactly they would get signature, but April 2nd seems to be the effective date. Transitioning now into emergency family leave, so this is the expansion of the Family and Medical Leave Act, and this is where those technical amendments to the FMLA really made very substantive changes. But because if you will recall, the original bill passed by the House would have extended 12 weeks of FMLA leave under a broad category of reasons, looking very much like what the Emergency Sick Leave Act looks like now. That has been pared back, and the only expansion to the Family Medical Leave Act is if an employee has a son or daughter whose school or daycare has been closed, or if the child care provider is unavailable due to a COVID-19 emergency. So that is a broad revamp of this provision, and I think because of the realization that imposing 10 weeks of paid FMLA on small employers was going to be horrifically onerous for those employers. And it's a real balancing act now, obviously, between trying to assist employees and trying to make sure employers stay afloat. So now this leave applies only to this particular situation where an employee has a minor child and their school, daycare, child care provider has been displaced due to the COVID-19 emergency. So this now means that a lot of folks who didn't have to deal with the FMLA because they didn't have 50 or more employees are now subject to the FMLA. And we've had a lot of questions and confusion about, well, does this mean me with 49 employees now have to comply with all the rest of the FMLA? No, this is expanded to those employers only on this particular prong, so not a wholesale opening of the Family Medical Leave Act. Under the emergency family leave, let's talk about pay. For the first 10 days of a leave, that's unpaid. A worker, again, can elect to use accrued vacation days or other available paid leave. As we saw from the prior screens, this is also covered by the Paid Sick Leave Act, so they could be paid under for those first 2 weeks under the Emergency Paid Sick Leave Act. For subsequent days of leave, there's a calculation again that workers will receive a benefit equal to at least 2/3 of their normal pay. And under this act, for those 10 weeks, the paid leave is capped at $200 per day and $10,000 in the aggregate. So again, a very substantive change to what that rate of pay was going to look like initially. So a higher rate of pay under those first 2 weeks under the Sick Leave Act, lower rate of pay under the Emergency Family Leave Act if that kicks in for those other 10 weeks. Wages required to be paid under this will, again, not be subject to the 6.2% Social Security payroll tax, so exempt from that. Under this, generally, the employee on leave must be restored to his or her prior position, just like under the FMLA generally, that somebody has to be restored to the same or an equivalent position. However, there is a built-in exemption for employers with fewer than 25 employees. So if during the course of the leave, that position has been eliminated because of the economic conditions, or there's some other changes in operating conditions because of the financial issues caused by COVID-19, that can create an exemption if the employer also makes reasonable efforts to restore the employee to an equivalent position, or if there's no equivalent position available, that employer with fewer than 25 employees has to reach out to that employee for up to a year if an equivalent position becomes available. So say small business, they stop operations for a time, or they scale back on operations, and then they later start back up after this employee comes off of the FMLA, the expanded leave. Then you have to reach out, contact them as you're beginning to expand again, and see if they want to come back for that equivalent position. One of the debates we had internally yesterday was, well, under the Family Medical Leave Act, leave can be taken intermittently. Is that the case in this situation, which could be quite a nightmare to manage? What we believe is that no, leave would not be available intermittently. The section of the Act and the FMLA that sets forth the right to intermittent leave was not amended by this new Act. And we do not believe that intermittent leave will be permissible. So no provision in that. In the regular FMLA leave, some leave can be taken intermittently by agreement with the employer or when otherwise medically necessary, which is not the case for this expanded leave. Another question that may come up is, can both spouses take leave? If a child's school or daycare has been closed, can both spouses take leave? It is a little bit unclear under this particular, under the language of the Act. Under standard FMLA interpretation and procedures, both spouses could take leave at the same time if they don't work for the same employer. At first blush, it would appear that that may be the case. However, the language of the legislation says that the employee is entitled to the leave if they need it to care for their minor spouse. So arguably, if the other spouse doesn't work outside the home or has already taken leave, arguably that spouse may not need it. But as a practical matter, it may be difficult to prove who's at home, for what reason, how is that playing out. So I think that may be difficult. And again, one of those areas where we're hoping to see a bit of clarification on as this plays out in the next couple of weeks before it takes effect. And I know we'll have a lot of questions coming up at the end, but at this moment, I'm going to turn it over to Kim to talk about the employer tax credits.
Great. Thanks, Debbie. And I will start off by saying that we here at Thompson Hine have a robust tax practice that can help with any questions you may have on tax credits. So we're going to go through this on a high level, but additional details can be provided from our tax group. So employer tax credits. The law actually does give employers assistance in paying for this leave by providing refundable tax credits for the employer portion of the OASDI component of the payroll tax. So that's the 6.2% employer portion of the Social Security tax. The tax credit differs depending on whether the leave is sick leave or emergency family leave, and it follows the amount that's required to be paid for the leave. So the sick leave credit for each employee is equal to 100% of the sick leave wages that are required to be paid to the employee under the Act. So back to Debbie's point about, can you apply this retroactively? The only wages that are subject to the tax credit are those that are required to be provided under the Act. So most likely, retroactive leave would not generate the tax credit. Interestingly, the tax credit is increased by qualified health plan expenses relating to those wages. We're not exactly sure what that means at this point. The law says that the expenses have to be excludable under Code Section 106, which means that it may have more to do with the value or the cost of the plan as opposed to the benefits that are actually paid out under the plan. But what those qualified health expenses are and how they're allocated to the wages is supposed to be addressed in future guidance by the Treasury Department. Sick leave credit is limited to $500 per day for those employees who are entitled to $511 per day, to those employees who are entitled to the $511 per day, and $200 for those entitled to the $200. Now, those employees who have self-quarantined for other reasons, that last prong, they are subject to the $200 tax credit because they're subject to the $200 amount of pay. And the total amount that can be taken in consideration for this credit is 10 days total. The credit is taken on a quarterly basis. So what you would do as an employer is take a look at how many days have been paid in prior quarters, and then you can take 10 minus those number of days. So ultimately, overall, it's no more than 10 days. Family leave credit, very similar. It's 100% of the family leave wages that are required to be paid under the Act. It is also increased by qualified health plan expenses that are related to those wages. It's also tied to the amount of pay that's required, $200 per day, and not more than $10,000 total. We'll then move to the benefit plan provisions of the Act. And I want to say up front that there are no benefit plan provisions relating to these new leaves. So for the paid sick leave, for the emergency family medical leave, the law does not indicate what must happen to someone's benefit coverage. Given that the Family Medical Leave has actually amended the Family and Medical Leave Act, the Family and Medical Leave rules that apply to benefit continuation while on a family and medical leave would apply here as well. And so that would require an employer to make that coverage available. Of course, there are a variety of rules that apply on how to do that, and we're not going to get into detail on that in this webinar, but just wanted to note that the rules that we all know and love about the Family and Medical Leave Act will also apply to the emergency family leave. Now, with respect to the paid sick leave, in most cases, benefit plans provide that as long as you're on a paid leave, you continue to participate in the benefits. However, there may be some benefits for which an employee has to be actively at work. For example, there may be some insurance policies that require the employee to be actively at work at the time a particular event occurs in order for the insurance policy to cover that event. So it's worth checking the plan documents to see how they would cover leave. The plan should address what impact on the benefit a leave of absence has. I will say in practice, a lot of plans are not clear about that. And that's led to some litigation, especially with fully insured benefits. So an employer at this point, this would be a perfect time to dig into your plan documents and take a look to see, does the document adequately and accurately describe how you intend to cover your benefit coverage during the leave? And do your insurance policies continue to cover employees during the leave? If you don't like the answer to that question, and you've got a self-funded plan, you can amend the plan. If you've got a fully insured plan, you can work with your insurance carrier to amend the policy if they're willing to do that. If you do have a fully insured plan and you want to make a change and you have a stop-loss policy that attaches to it, you're going to want to make sure that your stop-loss carrier is on board with the change as well. Unrelated to anything we've talked about this morning, required health plan coverage. The Act does require group health plans to cover certain services for free. Which group health plans must comply? It's any group health plan with at least 2 participants that are current employees. So that excludes retiree-only plans. For those benefit plan professionals on the call, if the plan is subject to the ACA market reform provisions, if it's subject to the other HIPAA special enrollment rights, it's going to be subject to this requirement, which means that accepted benefits such as hospital indemnity policies are not going to apply. And importantly, employer size does not matter. So whereas everything we've talked about so far today applies to employers with fewer than 500 employees, this requirement applies to all group health plans. What is the requirement? The group health plan must cover certain COVID-19 testing and related healthcare visits at 100%. 100% means no deductibles, no co-insurance, no copay. The participant cannot be required to pay anything for these services. And we have to provide this without any sort of medical management. So there's no prior authorization, there's no utilization review. It is pure coverage. What is covered? Testing. So that the technical language of the law we've placed here, I will say that it uses the term in vitro diagnostic products. In vitro means outside of the body in a test tube. I did have somebody, ask the question, in vitro, is this limited to people going through in vitro? Not in vitro fertilization. This is diagnostic testing that takes place in a test tube. So basically, the COVID-19 testing that's normally going to take place is going to be covered here under this law. In addition, the law requires coverage of certain items and services that are furnished to a plan participant during a healthcare visit that results in an order for covered COVID-19 testing. So that, when we're talking about visit, the law says office visit, telehealth visit, urgent care center visit, emergency room visit, wherever you're going to see a doctor and that doctor says, I think you need testing, that visit is going to be covered under these required provisions. But the coverage is only required to the extent that the items or service furnished during the visit relate to the furnishing or administration of the testing or the evaluation of the individual to determine whether testing is required. So if I go into the doctor with an earache and the doctor looks at me and says, oh, gee, I think you need a COVID-19 test, the services that the doctor provides to me for my earache are not required to be covered at 100% under the plan. Now, full coverage is required for items and services that are provided on or after the date of enactment. So we're beginning March 18th, so we're already effective, but only during the public health emergency declared by the Secretary of the Department of Health and Human Services. These public health emergencies typically run 90 days and can be extended. So it's unclear at this point in time how long we will be required to cover these items and services, but it is only during the period of the emergency. Good news for those employers that have high deductible health plans. Those of you who do have high deductible health plans know that a plan can't cover treatment, can't cover anything that's not preventive care before someone reaches the deductible, because if we did that, we'd be disqualifying the high deductible health plan and where employees would not be eligible to contribute to an HSA. Well, last week the IRS solved this problem for us even before the law was passed and said that if the health plan covers treatment and testing for COVID-19 prior to satisfaction of the deductible, it's not going to impact an employee's ability to contribute to an HSA. So everything that we are required to do under the law, we should be able to do without disqualifying our high deductible health plan. Thank goodness, that would put us in a very difficult position if it didn't. I did want to make a quick note here, though, that the law does require us to cover that a telehealth visit, if the telehealth visit results in COVID-19 testing. I don't know if and how that would occur, but if it does occur, that telehealth visit would be covered under the law. However, neither the law nor the IRS notice from last week addresses other telehealth services. So governmental agencies have been encouraging the use of telehealth services. Common wisdom suggests that it's probably better not to leave the house, not to take up room in a hospital, not to take up room in an emergency room if you can help it. So everybody's being pushed to telemedicine services. Unfortunately, we don't have guidance from the IRS just yet to say that we could provide these services for free without disqualifying a high deductible health plan. So if you're an employer that provides a high deductible health plan and you're considering waiving cost sharing for telehealth services to encourage your employees to use it, you should know at this point we don't have anything from the IRS telling us that that's okay. If I had to guess, I would guess that's coming. But we don't have it yet. So that takes us to the question and answer session of our presentation. We'll address the questions that were submitted in our time remaining, and we've been joined by Megan Glowacki, partner here in our Labor and Employment Group.
And thanks, Tim. Before we get started with the questions, I did want to make just a couple of other comments about some of the nuances of the two leave provisions. First, with regard to the emergency sick pay, an employee is required to give reasonable notice of the need to use it. So, you know, what is that? I mean, it could be that that comes up very rapidly. It could be if it's a foreclosure of a school or child care, there may be more notice involved. But also after the first day, you can require some notice as well. And exactly what that notice should be is not spelled out the way that we would like it to be, but you do have some ability to obtain notice from the employees. I also want to say that under both plans, the Secretary of Labor has been given authority to issue guidelines on a couple of things. One, the Secretary of Labor has authority to issue regulations to exclude healthcare providers and emergency responders from the definition of eligible employees. So we expect that we'll probably see something promulgated by the Secretary of Labor addressing that issue, although the Secretary of Labor is not required to do so. It's just stated that the Secretary of Labor has that authority. The Secretary of Labor also has the authority to issue regulations exempting small businesses with fewer than 50 employees from the requirements of these two provisions when the imposition of such requirements would jeopardize its viability. So I would guess that's something that's being wrestled with now, and Megan has a point to make too.
Yeah, but with the small business exception, it's important to note that with respect to the paid sick leave, the current reading of the Act would suggest that it applies to exemption from emergency paid medical leave, and then with respect to paid sick leave, only the provision where an employee needs to be absent to care for their child because of a school closure. The remaining paid sick leave availability would exist even though you have less than 50 employees.
And that's under the Paid Sick Leave Act.
Correct.
So just wanted to make those couple of points before we get started with questions. I know we have a few. I'm going to try to skip over the ones I think that we've already covered, and then we will field them as best we can, with the caveat that these things are changing all the time. So we're going to give you our best answer as it exists today, you know, but these things are constantly evolving. Question, if we have a mandatory shutdown due to COVID-19, is my company required to pay for 2 weeks full pay? And I read this to be just your company has decided on its own to have a closure to help minimize the spread, as we're being encouraged by many governmental entities to do. And my read is, in such case, that does not fall within any of the identified qualification components of either the Emergency Family and Medical Leave Expansion Act or the Emergency Paid Sick Leave. So I think your obligation would still exist. So for instance, if you shut the plant down, but now we go into an order where everyone's on quarantine, then I think it's going to kick in and you would be obligated to have, you know, have the payments as set forth in those two provisions. Let me skip down. Going to the next question, I think we've covered the effective date and whether it's retroactive, but can employers ask for documentation that the employee meets the requirements and how to track for the credit? I'll let Megan chime in on this one as well.
Yeah, this is a great question. Obviously, employers are concerned about the potential abuse of the paid sick leave or EFMLA provisions. We don't think it's quite clear under the Act what can be required at this time, and are hoping that the DOL provides some more guidance on that point. Our recommendation at this point is to move forward with your current notice and documentation requirements. So if an employee would be out for sick leave otherwise, to require that type of documentation. In addition, since most employers will be seeking reimbursement from the government for the paid leave, it does do us a benefit to record accurately who was on what leave and for which provision that it was used, And if someone simply says that they're on leave and we don't know why, we certainly can require that information to be provided. And if we have a concern that that is a bad faith use of the paid leave, to obtain additional documentation to support the need for leave.
Absolutely. And I think it is important. I think some employers are going to sort of a checklist when an employee may ask for leave so that you can accurately record which bucket it falls within. As Megan referenced, you're going to want to get your tax credits for this, and those vary depending upon the payments that are paid out. Is it 511? Is it 200? Is it 2/3 of that? And that varies depending upon what bucket that employee falls within. So you want to make sure that they are informing you which type of leave is being taken for this, and also for the abuse issues as well. Next question is, if an employee is awaiting medical diagnosis and is off for 4 days and released to return to work, but then goes out in 2 to 3 weeks for quarantine, does sick leave time start over, or is it reduced by previous days used? My read of the Emergency Paid Sick Leave Act is that a full-time employee gets 80 hours. A part-time employee gets a calculation based upon their average number of hours over a 2-week period. So that is what they get. So my read is that if they go out, come back, it doesn't start over, they're still entitled to that balance of that time, but it will be reduced by the time that they are out. Next question is, I want to understand how this affects collective bargaining employees. Megan?
Yeah, union employees can be traditionally very difficult to manage this type of federal legislation over, because we have strict requirements under a collective bargaining agreement as to specific things like perhaps notice of need to be on leave, documentation required, etc. Just like all of your non-bargaining unit employees, your bargaining unit employees are going to be eligible for this paid leave. If you feel like there are provisions in your CBA that do not squarely mesh with our ability to provide this type of leave, then that would be an opportunity to caucus with your local union officials to help come to an agreement as to how the leave is going to be implemented. There is a provision in the bill, in the act, that states that an employer who has a multi-employer plan that would provide benefits for this type of paid leave may pay into that plan as their obligation, and in paying into that plan fulfills their obligation under either of these two provisions. I've dealt with a number of collectively bargained organizations, and I'm not aware at this time of many plans that exist that really speak to the nature of the leaves at issue. But if you do have a multi-employer plan that potentially covers these types of leave needs, you should be looking at whether that multi-employer plan effectively is your paid sick leave or your emergency FMLA in this case. But those plans, I warn, may be few and far between.
And Megan, with respect to the benefit plan provisions of the Act, it's my understanding that whenever an employer changes their benefit plan, they have to work with the union and engage in bargaining. We've got this small change that's legally required. What are the obligations to work with the union with respect to changing our health plan?
Yeah, the same traditional provisions would apply. So if you're thinking about changing a benefit plan in response to this, you probably would not be able to without mandatory bargaining with the union over that. And depending upon what your collective bargaining agreement says, you may or may not be able to implement that after negotiations and impasse. If this is simply an allotment, if you will, giving employees the benefit of a paid sick leave day or 80 hours, or fulfilling the EFMLA leave provisions, it probably does not need to be bargained directly into the collective bargaining agreement, but you certainly would want to make sure that there are no hiccups with the rollout of that with your local bargaining unit.
Next question. Thanks, Mike. Next question. What will happen after the initial 80 hours? Should we have employees sign up for unemployment insurance? I think, there are a number of ways to handle those employees who may be out for the initial 80 hours of sick leave for whatever circumstances. There may be employers who are going to engage in layoffs. So that would have a different analysis. There may be employers who choose to put employees on unpaid administrative leave, which could govern that. There could be employees who have additional leave time available to them after the 80 hours, which would be, their opportunity if they are an employee and there hasn't been an interruption in employment during that time. And bear in mind that someone who is given emergency or who's given emergency paid sick leave may also qualify for the broader FMLA leave requirement. So if they are diagnosed, it may be a condition that falls within FMLA depending upon the severity and extent and all those other factors. So they may transfer into FMLA analysis at that point too. So it really is going to vary depending upon what your organization is doing and what the employee has available to them.
And how broadly the state unemployment is sort of expanding their opportunities to use unemployment insurance.
Right, which is also changing. Next question is, an employee is awaiting medical diagnosis and is can the employee with child care needs receive 2 weeks of sick leave and then request expanded family medical leave, and how would that be paid? So I think the question is, daycare or a school has shut down, the employee elects to receive 2 weeks under the paid sick leave, and then they want to go under the expanded family medical leave and take those 12 weeks. How is that calculated?
Yeah, and it's important to make sure we understand that the 80 hours is not in addition to 12 more weeks. The 12 weeks encompasses the first 2 weeks of being unpaid. So under this hypothetical, I think what we're asking is the first 2 weeks of emergency FMLA are covered by or are paid by the paid sick leave portion, although you have then utilized 2 weeks of EFMLA, and the remaining 10 weeks of EFMLA are paid at the 2/3 or up to $200. So important to make sure we understand that we're not getting 80 hours plus 12 weeks.
And Megan, have you been advising if someone, so say an employee says, I want to take Emergency Paid Sick Leave Act, my child's school is closed, but they don't designate FMLA leave. Should employers be self-designated, or should the employers be designating, okay, this starts the clock ticking as well? My gut instinct is yes, they should be.
Absolutely, because otherwise you're going to run into a position where, let's say, for example, you have two parents who work. Parent A says, I'm going to spend 2 weeks at home to care for my child whose school is closed. I'm going to take that as my 80 hours of paid sick leave, but the client, the employer, doesn't designate that as EFMLA. The parents switch, so parent A comes back to work for 2 or 3 weeks, and then the parents switch again. So now the employee says, I need to be out for time to care for my child whose school has closed. You know, I'm a little bit afraid that we're all trying to react in the moment, as everybody is, to the changing tides here. And if we haven't designated the first 2 weeks that occurred a couple of weeks or months now ago, that we might forget that that occurred. So it would be important where EFMLA can be designated to designate it, so that then we're not sort of inadvertently forgetting that 2 weeks of the EFMLA has already run.
Yeah, that's an important note.
Which I guess brings up a question about, can this be used intermittently or in one big block of time? And I think at this point we don't necessarily know, and would hope for DOL guidance to say, does an employee have to take all 12 weeks in one chunk, or can they break it up, like I just suggested, into 2 weeks here off and then 10 weeks there.
Yeah, we talked about that before, that it doesn't appear at this juncture based upon the language that intermittent leave would be available, because it does not cite to the intermittent leave provision, and this expansion of leave is not for medical purposes. But it is one of those things that we certainly are hoping the Secretary of Labor will clear up for us with some regulation. Was a question about who pays the employees. Does the employer pay it directly? Yes, the employer would pay directly, and then that tax credit, as I understand, on a quarterly basis with payroll taxes. Next question, if you have a new business planning to hire a few employees, does this program apply when you hire employees? It takes effect, for anybody who has fewer than 500 employees, it takes effect. The sick leave component takes effect immediately. The Expanded Family Medical Leave Act requires that an employee be there for 30 days before seeking that benefit. But this Paid Sick Leave Act would take effect for any employee, regardless of their tenure. And okay, here's a question. I had an employer who needed leave immediately for child care. We went ahead and granted it. Is this a problem? Megan, I'll get your thoughts. Certainly it's not a problem that you did that as an employer. I think in these circumstances, we see a lot of people doing what needs to be done and not necessarily relying on regulation. However, may you still be required to pay the benefits under these acts? Yes, I think you are. Sorry, we're just trying to scroll through these questions. We're getting a little bit of a technical issue here. Okay. Is there any provision to prevent employees from abusing this act? You can imagine some would say have access to daycare, but since their normal one is closed, and then continue to use paid FMLA. So again, scenarios where what can we do to prevent abuse of these? And there is a lot of concern that there could be abuse, especially given the fact that it's difficult to get into a doctor's office, it's difficult to get notes. What assurance can you have? And I know we've been wrestling with this. Megan, you want to chime in?
Yeah, I mean, especially with the eFMLA provision, until we see further guidance from the DOL, I continue to be of the view that our normal reaction when we believe that there has been abuse of FMLA, or somebody who is asking to take FMLA not in good faith appears, and that would be an investigation into the circumstances and surrounding of the request to take leave and your normal and typical sort of investigation practices. I will say it may be difficult to take leave, to investigate these types of issues, particularly since a normal FMLA abuse situation could be, I'm really not feeling well, I'm not capable of doing this, but yet employee ends up at Disney World, and it's much easier for us to analyze that. I think, if there's objective evidence that the employee does have care, alternative care for their child, that might be a situation that we could investigate whether abuse has been taken. But I would tread very lightly under such circumstances.
Next question is, if an employee is able to work remotely, do you have to extend the e-sick leave? The legislation specifically contemplates telework. So, for instance, qualifying need related to the public health emergency under the Expansion of Family Medical Leave Act says that qualifying leave means the employee is unable to work or telework due to the school closure. That same language is used in the Emergency Paid Sick Leave Act. So even if an employee falls within one of those need qualifications, if the employee is able to telework, these leave policies would not kick in. Next question, what if an employee is not physically ill but communicates mental health concerns related to COVID-19? Are they eligible for sick leave?
To be determined. I have had concerns about the language of the Paid Sick Leave Act, and particularly the language that indicates that an individual is experiencing symptoms of COVID-19 and what that really means.
Also the language that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So is that a mental health provider who says, yes, I understand this is causing anxiety, you should quarantine?
Absolutely. I mean, I think it's certainly possible that you could have employees who raise this issue, and until further guidance is provided, I think you'd have to analyze very carefully whether or not the symptom raised would be potentially covered and connected to COVID-19.
I had a question on the job for the last 30 days or 30 days in the past year. It does say this pertains to the Emergency Family Medical Leave Act, and then who becomes eligible. An eligible employee means an employee who has been employed at least 30 calendar days by the employer. So it doesn't say 30 consecutive calendar days, 30 calendar days. So I think it's reasonable that it could be interpreted to mean an employee who works, intermittently for you for, who has been there for 30 days. Maybe not even within the past year, but 30 days. So it's, again, language that's going to create a lot of confusion as we move forward. Question on the posting requirement for employers who have more than 500 employees. So posting specifically under these acts applies to employers, the acts themselves apply to employers of fewer than 500 employees. So the posting requirement would not be applicable to employers with more than 500 employees. Question for you, Kim. If allowed under the CAFE plan, can DCAP elections be reduced due to the decrease in child care needs?
Yes, so the question is, we've got a dependent care assistance program which allows employees to reduce their pay on a pre-tax basis and to put that money into a reimbursement account. That reimbursement account is then used to reimburse the employee on a pre-tax basis for eligible child care expenses. You make that election, you make it before the beginning of the year, and it generally can't be changed during the year except under certain circumstances. And the question is a change in child care needs one of those circumstances? Yes. So if if an employee needs more child care because school is out, then yes, they can increase their election to provide for that. If they need fewer dollars, fewer hours because they're at home now with the child, they can change that election as well. As long as the plan allows it, the cafeteria plan regulations would allow it as well. Okay. I think we maybe have time for one more question before we run out of time. For employers who have more than 25 employees, if we downsize operations during the time and laid positions off, what is the expectation of restoring a job?
Meaning that now before we go into this, and I'm sorry, I can't read the question. So before we go any further, we have 25 employees, we have downsized, and now we are fewer than 25 employees. I think there's an argument to be made that you now fall within the 25 employee exception, although, obviously that probably needs to be made in good faith at that point.
Yep. Well, thank you everyone for joining us today. We did not get to all the questions, but as I indicated earlier, we will follow up. For those of you who are not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. We do issue regular updates on a variety of topics, including the coronavirus. In fact, if you're signed up, I'm sure you've received a wealth of them in the last few days. But we thank you very much for your interest. We thank you for attending today's webinar, and enjoy the rest of your day. Thank you.